Our group will be presenting case project number 6, the Hard Luck Student. Our group members are Austin, Craig, Sally, Jason, and me, Braden.
Mabel Hardluck. I'm enrolled in a 2-year university transfer program at the College of Northern South Alberta. I hope to complete a BA degree with a major in sociological etymology and a minor in bingo hall management at the University of Southern North Alberta, located in Rosebud, Alberta. I have no idea what classes to take, and I need help from my student advisor. After I graduate, I have been guaranteed a job at New Arachnid Spider Ranch and Bingo Resort. I've been promised a salary of $80,000 a year, plus a car and great health benefits.
Hi, I'm Busy. I'm a car-headed student advisor at the College of Northern South Alberta. I'm here to assist my students to take the right classes to complete their degree.
I'm here as a professional advisor employed to the university and owes a duty of care to all the students who come to her for assistance. Because IMA is an employee of the university can be held liable for the tortious act an employee commits while at work, thus vicarious liability.
Hi.
Hi.
I'm Mabel.
I'm Ima.
Nice to meet you.
Nice to meet you. Let's fill out this student worksheet form.
Great. Ima, what do these big red letters mean?
The student worksheet form has clearly stated that Mabel is responsible to complete the form accurately and to ensure the receiving institution knows about her. She clearly owes a duty of care to herself in ensuring that it is completed properly, even though Ima has stated that she will help her every step of the way. Through signing this waiver, she is voluntarily assuming the risk of damages. The red text has serious implications. This is an example of an exemption clause in which a party attempts to significantly limit or eliminate its liability under an agreement. This must be brought to the attention of the customer at the time the contract is made.
Don't worry, be happy. I'll help you every step of the way.
Mabel checks in with Ima after every midterm and then end of term final exam periods. Mabel heard from a friend the transfer process can be tricky and wanted to make sure her course study was correct.
My midterms are going great. Final was amazing, got 100%.
Nice.
Did really well in school.
Good job.
Can we ignore that?
The mail.
Denied?
How could this be? I took all the courses that Ima told me to. You lied to me. I took the courses that you told me to and now they won't transfer. I've wasted a year of my life.
I tried my best. No one can understand the transfer guide. You'll have to appeal to the appeals committee of CNSA.
Mabel said she relied completely on Ima and trusted her. Mabel said she wanted all her tuition back from CNSA so she could pay for the qualifying year at USNA. She was also upset that she'd be delayed in starting her $80,000 per year job because she would need at least one more year to complete her degree. The committee heard from Ima and accepted written submissions from the college officials, but did not allow Mabel to question Ima or any of the other college officials present. The committee then adjourned to a private room and returned saying that they did not have jurisdiction to return tuition or to give damages for added qualifying year. Unfortunately, therefore, Mabel Hardluck was now out of luck.
I want to sue.
Because she was promised a job after graduating and it was provided in writing, it makes it an official contract. Because the job is offered once she's done school over a year, the contract must be in writing. Since Ima stated no one can understand the transfer guide, it should be the university's duty to ensure the transfer guide is easily understood by employees. Professional liability. Although Ima may be a kind-hearted student advisor, she is still subject to professional liability. Experts are simply people who hold themselves out to have some specialized knowledge or skill not generally available or known to the public. Professionals are usually experts who may belong to professional organizations such as universities and practice a specific area of service. The liability of professionals may be found in contract law or based on fiduciary duty but recent expansion of liability has been in the area of tort law, specifically negligence. There's a case of misrepresentation in terms of negligence because Ima has a duty of care owed to the students, seeing as that is her job as an advisor. Instead of Ima telling Mabel, "Don't worry, be happy, I'll help you every step of the way," she should have stated up front that she didn't understand the transfer guide before Mabel signed it and the damages were done. If she had superior knowledge, she needed to know that her statements would have negative consequences. Negligent misrepresentation is when it can be established that a party carelessly provided material but false information. Negligent misrepresentation may be established. With this tort, all four elements of negligence must be present. A duty of care was owed to the student. Breach of duty. They didn't act as a responsible, reasonable person would if they were an advisor. They would know which courses to take and what to amend, regardless if there was also a duty of care owed to the student herself. Causation. It was foreseeable that she would not be accepted into her program without taking the proper courses, and that it would delay her potential job lineup as well. Damages. Not being able to get into her program and delayed graduation by a year. Delay of job of $80,000. Extra finances being put into a year's worth of school because the previous year was basically wasted.
Due to the Appeals Committee of CNSA, it falls under the category of Administrative Tribunal. Being an administrative tribunal, they have specific procedural protocols, and Mabel needs to exhaust all remedies before going to court with the Appeals Committee. Although the University Appeal Committee have limited ability to give money, they may have the ability to give free tuition. However, this would not be beneficial to Mabel because she'd be taking a qualifying year at UNSA, not CNSA. The committee did not act in the best interest for procedural fairness with their protocol because they did not allow Mabel to cross-examine Ima or question college officials present.
Because this is a case of misrepresentation, the contract is voidable. A voidable contract exists and has legal effect, but one of the parties has the option to end the contract. She has the option for remedies of recession and damages. Recession is when the victim of negligent misrepresentation retains the right to have the parties to end to the contract return to the original positions. Damages are available as a remedy where misrepresentation has become a term of the contract that is breached, and the misrepresentation is fraudulent and there is negligence. The
pecuniary
losses she faces are lost wages, car, health benefits, and the non-pecuniary losses she faces is the loss of a year endured from non-applicable courses. Because Ima is considered under vicarious liability at CNSA, CNSA is in breach of contract with Mabel due to Ima's lack of responsibility when it came to ensuring the correct courses were being taken. There was an improper or incomplete performance of the obligation that was set out in the agreement. There needs to be a reasonable level of performance from Ima, since her job as a student advisor is to properly inform her students of the classes they should be taking in order to graduate. This can be seen as a breach of fiduciary duty because it's a situation where Ima has advised Mabel and reliance was placed on that advice. Mabel and Ima had a relationship built on trust. By checking in with Ima after every midterm and term final exam, Mabel shows loyalty and good faith to Ima. This happened over the course of 2 years, and Ima never gave her reason to believe that she couldn't rely on her advice. A fiduciary duty arises when one party places a considerable amount of trust in another, making herself particularly vulnerable to any wrongful actions of that trusted party. When a person places trust in a professional, the professional has a fiduciary duty to act in the client's best interest. Loyalty and good faith by the professional are demanded.
There's a case of misrepresentation. That sounds not correct, but that's okay. Let me try that again. Breach of duty, breach of standard of care. Breach of duty, breach of standard of care.
Of the standard of the, it's a breach of the duty of the standard of care.
And for Fox Creek.
Complete a BA degree with a major in sociological Northern.
Recording or is it not recording?
And fix it. Just leave it on the whole time.
You can pretty
Making himself. Why is that in there?
One sec. I gotta go over this one more time.